one agency to another.
Call Charles Cheval.
Thank you, Mr Chairman. Mr Chairman, I want to commend what David Parker has said. I think it is true that as the debate has progressed, our understanding of this very complex piece of legislation has greatly improved. I think it's pointed to the complexity of the legislation when we're considering Part 5 and the interplay with the supplementary order paper number 12, which dates from Tuesday 6 March, so it's just over 2 weeks old. And the complexity was brought home to me when I worked with David Parker to try to come up with some amendments to achieve the aim that we had discussed with the Minister but not managed to get agreement on, which was the inclusion of the Serious Fraud Office. I thought, well, I'll just... Part 5 is the part of the legislation that deals with all the other acts of Parliament and all the other agencies that we are conferring the standardised set of rights and duties on in the search and surveillance area, and David Parker mentioned some of them. We're amending legislation as complex as the Dairy Industry Restructuring Act 2001 and as banal as the Dog Control Act 1996. That is a pointer to the complexities here. But the other complexity relates to the interplay of the bill itself with the substantive supplementary order paper number 12, the 93-page set of amendments to the bill itself. And I do have to say this in passing, Minister. While I've praised you for your willingness to negotiate, it would be, in my view, a little bit over the top to claim too much regard for process as an excuse not to deal with the Serious Fraud Office in this context, given that your supplementary order paper makes a series of pretty significant amendments to the Substantive Act, which had never been near a select committee or a public consultation process. Let's just not make too much of that point if it is to be used as a reason for not dealing with the SFO itself. The supplementary order paper itself basically makes most of Part 5 of the Act redundant. And what it does is it replaces many of the references to the various agencies and powers with a new schedule to the legislation. So in order to try to fit the Serious Fraud Office into the bill, my supplementary order paper first of all inserts would insert a new clause 276A into the bill. The reason that it would appear there is all due to the alphabet. It would insert amendments to the Serious Fraud Office Act 1990 between amendments to the Resource Management Act 1991 and amendments to the Sale of Liquor Act 1989 in alphabetical order. And those amendments would be these. Basically, first of all, we'd start off by repealing Sections 5 and Sections 9 of the Serious Fraud Office Act. Now, again, to correct a point that the Minister made from the Chair a little earlier, this wouldn't create any vacuum or lacuna in the powers of the Serious Fraud Office. It would happen on the enactment of this legislation and not before. So they wouldn't lose anything in the present sense. They would continue with their powers up until this legislation got royal assent. But what the supplementary order paper would do would be to repeal Sections 5 and 9 of the SFO Act. Now, we've canvassed what those sections do, but I think it was obvious from an exchange between Dr. Calder and my colleague Ms Dalzell that we still haven't managed to get this across. Section 5 of the Serious Fraud Office Act, as it's framed now, Mr. Chairman, I'm going to describe, Mr. Chairman, what it does as follows. Section 5 allows the Director of the Serious Fraud Office to require the production of any piece of paper. Doesn't need to go to the court, doesn't need a warrant, doesn't need any safeguards, can just say, I want this piece of paper, or all these pieces of paper, or this electronic version of the piece of paper or pieces of paper. And the Director doesn't have to go to a court, doesn't have to make a case, doesn't have to undergo any process or safeguard in order to do that. He simply, and it is a he at the moment, issues this requirement and it must be complied with. So that's the first section that would go under this proposed amendment. The second section that would go is section 9, which gives a further power to the Director, and that is to say, again, without any safeguards, without any need to persuade a judge or to get a warrant, I want you in my office to answer questions at this time. He can say that to anyone on any occasion, and again, there are very limited opportunities to object, and certainly no requirement for prior judicial approval for the exercise of that power. So those sections would go, and they would be replaced by two very simple provisions. Basically, they would be replaced by section 6 and section 10, which would be amended as follows. They would basically have the following words put in: the provisions of Part 4 of the Search and Surveillance Act 2012, as it will be, apply. So all that happens is those exceptional powers would go, and the Serious Fraud Office would be brought into the same regime that would apply to every other state agency bar the SIS once this legislation comes into force. Very simple surgical exercise, and as David Parker told the committee in his previous contribution, this was something that was raised and discussed at Select Committee. It was raised, as I understand it, by submitters as a desirable thing to be done. It was raised with the officials, certainly by David Parker, as something that he would like advice about. And as we know from the news media sources that he quoted, it's something that was canvassed with the previous minister, now the Minister of Justice, and we have on record reported by her predecessor, Simon Power, her response. Now, it's okay that that response is no. We understand that. We don't like it. We don't agree with it. But, okay, it's no. But let's not dress it up as a no that's based on any particular respect or regard for procedure or process. Let's just understand that it's a no. What members on this side of the House are trying to do in this debate, and we've tried to do it in a civilised and restrained way, is point out that, yes, Dr. Calder, it makes a lot of sense to provide all these safeguards across the board in this bill. What it doesn't make sense to do is to leave the Serious Fraud Office out from the time that this bill starts to apply, because you've got one major agency of the state, probably in light of what David Parker said, the major agency that we need to have working well in this area, because we want organised financial crime to be prosecuted and dealt with appropriately, but it will stand out from the regime that we're putting in place in this bill. So all the good stuff, all the protections, all the procedures that you've rightly praised, Dr. Calder, still won't apply to this major agency. Those draconian powers under Section 5 and Section 9 will continue to apply outside the framework of this bill. And no dressing up any arguments around process and procedure can hide the fact that that just doesn't make any sense. It isn't logical. It leaves a major hole in the code that this Parliament now intends to enact relating to search and surveillance powers. Everyone else has protection. Everyone else must go to the court. Everyone else must get a warrant. Everyone else must make a case to a judge, except the Director of the Serious Fraud Office. And again, we can hear general claims about how important it is for these powers to continue, but it doesn't make any sense within the scheme of this legislation.
The Honourable Judith Collins.
Chair, there's a couple of issues I want to deal with. The first is the issue around